Good afternoon and welcome to our third HR quality update this year. My name is Pieter de Ruiter, Senior Associate by Pallas Attorneys at Law, and today I'm joined by my colleague Marcel de Vries, one of the partners of our firm. Welcome, Marcel.
Thank you.
And today we're going to discuss with you several topics on Dutch employment law. So we're going to give you a couple of updates on upcoming employment legislation. And then after that, Marcel is going to tell you all about reorganization, the ins and outs, an overview of the rules, best practices, things like that. Then after that, I'm going to take you in the exciting world of settlement agreements, the do's and don'ts, why do we have settlement agreements, and in the end, we're going to have a Q&A in which we'll have the time to provide us with questions, and we hopefully can provide you with the answers on that. Of course, it's possible to ask your questions during the webinar. They will pop up on my screen right here. We will try to answer those questions during the webinar, and if not, we will answer those by the end of the webinar. One of the questions I can already answer. The slides of this webinar will be shared with you afterwards. And of course, we also have a couple of poll questions standing ready for you. So pay attention, and then we're gonna have a very hopefully interactive webinar. First off, Marcel is going to tell us something about, I think, the law on the clarification of labor relations. So, Marcel, take it away. I'm going to give you the remote.
Excellent. Thank you, Peter. All right. The first update that I would like to discuss with you is the Bill Labor Relations Clarification and the Legal Presumption Act. So, a lot of words for one bill. And actually, this bill aims to end false self-employed relations and also clarify the rules on employee and self-employed qualifications. As we all know, many work relations contain elements of both an employment contract and also elements of being self-employed. And the key factor in many of those situations is there the existence of a relationship of authority or not. And this bill actually tries to help and to give new indicators to determine and to assess whether a work relation qualifies as an employment contract or as a situation of being self-employed. And actually, the first element is the introduction of a legal presumption for being an employee. So if a worker is working on the basis of an hourly rate of less than 33 euros, which is excluding VAT, then the legal presumption exists that this person is working on the basis of an employment contract. So that means, in fact, that this person could, in case of discussion, claim that the work relation is an employment contract, and then it's up to the employer to come up with valid arguments and counterproof and to underpin that this work relation should not be qualified as an employment contract. The other element is the clarifying the criterion of the relationship of authority, as I just mentioned in the definition in the law of employment contract. And actually it consists of two indicators for the existence of an employment relation. And the first one is that an employment contract is actually considered to be the agreement in place if the work is, the element is that work-related control exists or organizational control exists. Well, maybe a little bit vague terms to express that, but then relevant circumstances and factors are, for instance, whether the worker receives instructions on the work content, whether the work is also being monitored, if the worker is embedded in the organization of the work provider, if the work that is performed is actually the same as regular employees. And so these factors are important to determine whether this relationship of authority exists or not. Then the other element is more what we call a contraindication for an employment relation. And that's actually more that if the person is working at one's own risk and expense, and that is normally an indication for the existence of a situation of being self-employed. And then the indicators and circumstances are more that the work is more specialism and that not exists within the organization of the work provider. A person is also bearing on financial risk, for instance. So these are important elements to indicate that work relation will be based on self-employed. Well, this bill has been submitted actually for internet consultation, and the results and the responses were quite negative. For instance, also what is embedded in the organization of the work provider, because that's also quite vague. Well, and that actually did not withhold the minister to go ahead with this bill. So now it has been submitted to the Council of State, the Raad van State, quite recently, and the effective date that it should enter into force is the 1st of January 2026. Well, then we have the strange situation that this this bill is, of course, not an act yet, and it may become a law at the end. But that's for a certain period of time. There is uncertainty and unrest still about qualifications. But the tax authorities, in the meantime, they did announce that they are going to enforce, as from the 1st of January, the act that we currently have in place, and that is actually that DBA, also known as the Act on the Assessment of Employment Relationships. So that's, of course, a little bit same situation that after, 7, maybe 8 years of the tax authorities not taking any enforcement measures whatsoever, and that this announcement now has been made quite recently. So yeah, please bear in mind that this may take place and most probably will take place. Most probably in sectors where they expect that there are more vulnerable employees that need to be protected, and that they work on the basis of employment relations which are maybe qualified as being self-employed. Well, it should be considered an employment relation. So, for instance, maybe in healthcare and construction, for instance. And the other component in this discussion is always, well, do the tax authorities have enough people to do all the actions and enforcement actions that they have in mind? But at least good to know that this is something which has been pre-announced by the tax authorities, that enforcement may still take place, which could mean that additional tax assessments may be imposed, maybe also some penalties in case of situations like that. So be aware at least.
All right. Thank you, Marcel.
Welcome.
Yeah, I will continue with another part of the legislation, being the more security for flex workers, in the Dutch meer zekerheid voor flexwerkers. And this legislation is part of a package of measures to provide more quote-unquote security for workers and more agility for entrepreneurs. And the bill that Marcel just discussed is also part of that package of measures. So the cabinet is aiming to introduce those bills simultaneously. But this specific part of legislation aims to provide stricter rules for temporary contracts and strengthening the position of on-call and temporary workers. So what does that more specifically entail? The legislator wants to introduce a so-called basic contract, a fixed basic contract, which should replace the current 0 hours and min-max contracts, so 0 uren contracten and min-max contracten. And what the basic contract does is providing a guarantee of a minimum amount of hours for the employee. And on the other hand, is providing flexibility for the employer to also call the employee above that minimum, but not more than 30% of the original agreed upon hours. And in that way, the legislator is trying to create more flexibility on the side of the employer and more certainty on the side of the employee. Another important topic in relation to this legislation is that the phase system for temporary workers will be adjusted. So the phase system is a system consisting of phases A and phases B that applies in the temporary employment industry, that provides a temporary worker with more rights and better protection against dismissal the longer the temporary worker works for the temporary employment agency. And what will happen is that phase A is currently 78 weeks, and that period will be deducted to a maximum of 52 weeks, so 1 year. And phase B will be shortened from 6 contracts, a maximum of 6 contracts in 4 years to a maximum of 6 contracts in 2 years. Effectively meaning that phases A and B can never be longer than 3 years in total versus 5.5 years as it is now. Another element for temporary workers will be that the pay ratio requirement is expanded, loonverhoudingsvoorschrift. Temporary workers are now currently entitled to the same terms and conditions as the same employee of the company for which they are hired in. With respect to wages, hours, things like that. But that requirement will be further expanded to also other conditions of the employment, such as a bonus scheme and pension. And finally, last but not least, there also will be a change will be made in the statutory rules regarding the so-called chain scheme. And the chain scheme are the rules that apply in case of a succession of employment agreements for a definite period of time. So currently we have a maximum either of 3 years, so after 3 years you get a contract for an indefinite period of time, or after more than 3 contracts for a definite period of time. And we then have a chain of employment agreements for a definite period of time. And in order for those contracts to count in that chain, the contracts must succeed each other within an interval of no more than 6 months. So within 6 months, you have to have a succeeding employment contract. And that interval will be changed or will be more or less eliminated and replaced by an administrative expiration period of 5 years. So in the current situation, you could have 2 contracts in, for example, 2 years, and then after a period of 8 months between those contracts, the chain will start again, will start over. But under the new rules, you're still in that chain and you're already with your third contract. So that's more or less the measures that are included in that legislation. And in March of this year, the bill was submitted to the Council of State, the Raad van State, for advice. That advice is still pending. We're still waiting the advice from the Council of State. And I think, if I'm correct, in June of this year, there was also internet consultation for civilians and companies, so they also could provide their input for this bill. That internet consultation is closed last week. So after we have that input, or the input and advice will be reviewed by the minister, and if necessary, the bill will be amended. And after that, the bill shall most likely be shared with our parliament for further review. And likely, like I said, the implementation, I think the cabinet or the department aims to do that simultaneously with the bill that Marcel also referred to. So I think that's that for our updates regarding employment legislation. Then we come to, I think first restructuring, reorganization. You're going to tell us all about that, Marcel. And I think you're going to start with a poll question.
Yeah,
if I'm correct.
Correct. So actually, I would like to elaborate on reorganization and also to give you more or less a heads up on the main rules in relation to reorganizing your business. But I would like to start indeed with a poll question to come back on that later in this webinar. So the question for you to answer, and hopefully you will also give your answer on that, is: do you have a social plan in your company that is applied in case of redundancies? So you can easily say yes or no, and then hopefully we will see the feedback that you also provided to us later in this webinar. Yeah, so the reason for choosing also this topic is that we see in our practice that there's quite some layoffs going on at the moment. And also if you look at simply recent headers in newspapers, for instance, mass layoffs in tech industry, but also last weekend, also in newspaper, huge layoffs with WeTransfer, for instance, But also in our practice, we noticed that quite some companies are reorganizing their business, or they have concrete plans to reorganize their business. And that can be for various reasons, of course. That can be for financial reasons, can be for organizational reasons. I will elaborate on that later in my presentation. Can be for other reasons, and can also be for more technological reasons, for instance, company move, whatsoever. And of course, I cannot be complete on this topic, because I think we would need maybe an hour or maybe 2 hours, but at least I think it's good to address some of the highlights on this topic. And one of the essentials in case of reorganization is the preparation phase. So it's crucial to be well prepared, and that also starts with preparing what we call a reorganization plan. And this is actually a clear outline of the business case, the business rationale that you claim and that your company has in order to restructure the business, and which will most probably then also mean that you have to eliminate certain roles within the company. And it also means in that reorganization plan, you're also going to give an overview of the current market circumstances of the company, for instance, which measures you are forced to take, or what are the alternatives if you don't take the measures, and also what is the impact on the organization. So you also need to explain how the organization looks like now, but also what the intended organization chart will look like in case of restructuring a reorganization. Also, does it mean that new positions will come? Maybe there are positions that will be eliminated, but maybe new positions also need a job description that you need to pay attention to already in the pre-phase, because that's important to oversee the whole package actually of steps that you need to take. And of course, very important also a timeline, because you also would like to know, okay, what is the date that you would like to establish and effectuate the reorganization. And it also helps to determine which step should be taken when, and what action should be taken. And so, well, this reorganization plan is actually the heart for your whole restructuring, and because it will be used also in discussions, for instance, with the Works Council, and if you need to come up with a request for advice. It will also be the key document to fall back on in case you need to proceed with the UWV procedure, but also for maybe individual discussions with employees or their lawyers. It's important that you do have the backbone ready for your restructuring. Yeah, so what is important to understand is that if you are working on this reorganization plan, that you also need to keep an eye all the time on the rules that apply, and that's what we call the UWV implementation rules on economic dismissal. And please be aware that you do use the last version, and that maybe sounds well, why would it be a difficult point? Because there are many versions available if you look at the internet. And it would be a pity if you don't take the last version and you miss important details. So the last version is the version of the 1st of April 2023. These are policy rules. It's not a law, but it's very important because this is also the framework that UWV uses to, at the end, also assess your request for termination of employment. And also it gives a very clear overview of the information that you need to submit depending on the precise business economic ground that you bring up in the discussion about termination. Well, if you are ready and you went through the prep phase, and you also may be ready to set the next step in the intended reorganization. Make sure that you also timely involve the Works Council or maybe another employee representation body that may exist within your organization. I will come back on that as well. Check the applicable collective labor agreement, if any, to see if there are any special consultation or reporting obligations that exist in case of restructuring. And then the next step is actually to submit what we call a so-called A form with UWV in order to formally start the termination process. Well, actually, that's quite a simple form with just some basic information that UWV would like to have, with reason for termination of the employment contract, who are the individuals involved in the reorganization, and the main reason for already filing this form, and that's something you do before the announcement of the restructuring takes place, is that you can try to prevent that an employee will report sick and hence can claim protection based on the sickness that this person may have. The key process steps after filing the A form is that you will be given time to enter into discussions with the individual or individuals about a potential settlement agreement. And so you will receive 14 days for negotiations. In the meantime, the employee is going to consult on the draft settlement agreement, the termination offer that is made, and possibly also on the grounds that you have presented for terminating the employment contract, and also the ground for restructuring your business. And then hopefully you can come to a settlement. If that is the case, then you still need to take into account that the employee has a reflection period of 14 days. So in the meantime, you still keep the process running with UWV, because otherwise you may still have the problem that someone may have protection based on reporting sick. Well, if there's no settlement agreement, then you need to proceed with the termination procedure through UWV, which means that you need to submit the form B and C, which is actually the more substantial part of your outline and reasons for restructuring business and eliminating roles. And that also means that you need to fill in quite some paperwork, and of course, lawyers can help you with that. We can help you with that. But it's not just a very simple way of filling a form in, and it will take you 1 hour and it's done. And it also means that you need to provide a lot of information. That could be financial information, it could be org chart, it could be forecast, also in case of financial reasons that you claim to have. So it's a bunch of information that you need to deliver to UWV in that case. Well, in the meantime, after you have submitted all the information with UWV, the employee can come up with a statement of defense. And at the end, there may be additional questions from UWV based on the information that they received, your request for termination, the defense of the employee. And based on that, there may be an additional round of submitting reactions with UWV. And then there will be a decision of UWV, which will be either positive for you or negative. If it will be positive, you will be able to give notice of termination of the employment contract with observance of the notice period. The good thing is that you may deduct the procedural time that has taken for UWV to handle your dismissal request, but still at least 1 month notice period will need to be observed. Well, in that case of positive decision of UWV, you need to at least pay the transition payment and the statutory compensation, and also keep in mind that at the end, this decision of UWV may also be appealed by either the employee or, in case of a negative decision for you as employer, and by yourself. And then you need to go to the sub-district court to ask for a reassessment of the case and try to get another decision. Well, shortly about reasons for termination. I already mentioned a few of them. It can be for financial reasons, can be for organizational reasons, and in each of the reasons that you provide, you need to come up with a lot of information. So financial accounts for the financial reasons, but also a forecast of what if we don't take the measures, what will then be the effect on the financials of the company, the future of the company. And that's something you need to prepare well before you need to submit that to UWV, of course. And so it's important that you make sure that you have all this information and documentation ready. And also in case of cost reduction, and you say, well, we need to do a cost cutting exercise here within our company, and which also includes that we need to do the cost cutting in staff, and that you can also show which other measures you have taken to already do the cost cutting on other parts. And so, for instance, to maybe make deductions on the rent that you pay to the landlord, etc. And so all these elements is also something you need to provide to UWV. Well, the order, in order to terminate the employment contract of someone who has an indefinite contract, let's take that as a starting point, you first need to terminate temp contracts, which means temporary agency contracts, but also on-call contracts. And of course, it should be within the domain of where you are going to reorganize the business. You also need to terminate fixed-term employment contracts if they terminate by operation of law, which is within 26 weeks of the moment that you file with UWV. And so that's also something to take into account. And then you come to the other category of employees in scope, which are the people working on the basis of an indefinite employment contract. And so that's definitely something to take into account, because otherwise your reorganization may fail simply because you made the wrong choices in who you let go. Yeah, in terms of who is eligible for termination and which persons you may need to terminate their employment contract, you need to apply what we call the mirroring principle, afspiegelingsbeginsel. And without going into too much detail in this webinar, but you need to classify people in age groups based on positions which are interchangeable. And so if they belong to the same function group, for instance, maybe a receptionist and a telephonist, and they may have different functions, same function group, and then you need to apply the mirroring principle in order to determine who should leave the organization first and who has the strongest right in order to maybe keep his or her job in the company. Another important factor is replacement. Statutory obligation. You should make, as an employer, maximum effort to try to redeploy employees who lose their job based on redundancy reasons. And it also means that you need to look at flexible employment contracts, as we already mentioned. And so that means that maybe some people have fixed-term employment contracts which may become available, positions may become available for people in indefinite contracts, and so they have priority over flexible contracts. In addition, pay attention to redeployment by having redeployment interviews with people. It's also one of the key questions that UWV is going to ask in the forms. And did you have any discussions about redeployment with employees? And then you also need to be able to underpin that and to show that, to demonstrate that. So put in writing. That could also mean that you need to involve vacancies that exist within the group of companies that you form a part of. And so not only in the Netherlands, but maybe also broader. And it could also mean that in this interview report, you're also going to write down, okay, are you interested to work abroad? If the answer is no, have that confirmed, because that will help you also to show that you did the max you could in order to try to redeploy an individual. And of course, you also need to look, that's also a statutory obligation, to see whether maybe a position can be made suitable for an employee who's made redundant by training or education. Yeah, keep in mind that there are some restrictions in giving notice of termination. So for sick employees, pregnant employees, but also Works Council members, special rules apply. And so you cannot follow the process through UWV. But in that case, you may need to still try to come to a settlement agreement, or eventually you may have to go to court in order to terminate the employment contract. Yeah, I already briefly mentioned it. So when it comes to termination, if you have a positive decision of UWV, at least then you need to respect the notice period. At least you need to pay the transition payment. And also at least you need to make up a final settlement of accounts, which takes into account the holiday allowance and vacation days. And that's in case of not discussing a settlement agreement, but simply you did receive permission to terminate the employment contract, then these are, let's say, the mandatory elements. And of course, you can still see where you can add some extras, for instance, offer outplacement support, additional compensation, for instance, a signing bonus, or to do something with the post-contractual obligations, such as a non-compete or a non-solicitation clause. And that could also be based on a social plan. So maybe we can see the result now of the
already after.
Like the jury of the Eurovision Song Contest.
No, maybe good to.
May I have the results of the poll?
I have the results, and maybe good to repeat the poll question. So, do you have a social plan in your company that is applied in case of redundancies? 22% of the participants said yes, we do have such a social plan, and 78% of the participants said no. And there was one interesting comment from someone who said that, we had a social plan with our previous reorganization, but we don't have a standard social plan. So I answered the question, therefore, on a no, because in a future reorganization, I don't know for sure whether we have the same social plan or we even have a social plan.
Yeah, okay, good to know, and good addition. So that means almost 25%, almost out of four does have a social plan, which is interesting to know, because that already gives you a basis to fall back in discussions about termination conditions, and maybe also interesting for the next topic about your settlement topic, Peter. Thanks for sharing this information with us. And then I will proceed with the last part of my presentation. Yeah, and that means collective dismissal, because special rules also apply in case of collective dismissal. That's the case if we talk about termination of employment contract of 20 or more employees within a period of 3 months, and then also within a specific UWV region. So please be aware that in that case, you need to provide timely notification of your plans to UWV, in which case you also need to observe 1 month waiting periods, which means that you cannot immediately file the individual dismissal request with UWV, and also need to reach out to the trade unions if they are active in your branch of industry, of course. And why this month? Because in the meantime, the unions and maybe also the Works Council would like to discuss and negotiate a social plan with you, and also to try to influence the situation of is this reorganization indeed necessary or not. Yeah, I already briefly mentioned the Works Council. Please bear in mind that you involve the Works Council in a timely manner, which means that you still need to give them the possibility to come with an advice that gives them the possibility to still influence the intended plans that you have to restructure the business. If you don't do that in time, and then you may receive either a negative advice, or at the end you may end up in a situation of litigation that they go to the enterprise section of the court, and the Court of Appeal, the Ondernemingskamer, which may not only cause delay, but also maybe that measures may be imposed in that situation. So take the Works Council seriously and involve them in a timely manner. But also be aware that if you don't have a Works Council, maybe the size of your company is smaller because you don't have 50 employees. Also, in organizations with 10 employees, but less than 50 employees, consultation obligations exist towards staff meeting, personeelsvergadering, or maybe a staff representation, PVT. And that's, for instance, the case in case of loss of employment, but also if there is a significant change in employment, working conditions, or working circumstances of at least 25% of staff. Last comment, I started with preparation phase. Actually, one of the other important elements that you also need to be aware of from the start is communication, and that you also, we would recommend at least that you also come up with a communication plan, and because you need to communicate in a timely manner to many stakeholders, not only the redundant employees, but also what are you going to do with non-redundant employees, what is the message that you are going to give to them in order to keep them with your company. The Works Council already mentioned unions, but also shareholders, supervisory board, and press, for instance, and because they may also be very keen to understand what's going to happen. And that's also something you would like to maybe address yourself and be prepared for any questions that may come up from these stakeholders. So also a key element in the whole reorganization process. Conscious of time, I give this one to you.
Yeah,
in order
thank you, Marcel.
to go to the next topic.
Maybe we can do one question in the meantime, because we're getting a couple of questions in the chat. Someone would like to know which timeline should be taken into account for the Works Council process.
Yeah, well, let's say general timeline is difficult to give, but at least it's crucial that you do involve the Works Council, as I mentioned, in a timely manner, which means in a pre-phase. And of course, it's too late if you already say, well, we have everything already ready and we're about to file with UWV, for instance, because then they will counter that and say, well, we did not have a chance to influence it. And that means more early, and maybe you can also already inform them first about the intention and the plan that you do have. And if it's become a more concrete plan, that you do involve them and say, okay, now this is also the right moment to come up with a request for advice in writing.
Yeah. All right, great. So we're closing off the topic of reorganization. We're going to continue with one of my favorite topics in Dutch employment law, settlement agreement. When you hear the word settlement agreement, at least in our practice, people usually think about, okay, that's a termination of the employment contract. It comes in many forms. So we have the settlement agreement. I just saw on Marcel's slides, VSO, termination agreements. But I wanted to start with that a settlement agreement is actually an agreement that's defined under Dutch law. So it's qualified under Dutch law in Article 900 of the Dutch Civil Code of Book 7, and has its own legal regime. So it has its own set of rules. And so it's also used not only in our employment law, but also, for example, in family law or in rental law. And settlement agreement is used in order to resolve an uncertainty or dispute between parties in their legal relationship. And the upside from a settlement agreement that it's possible to deviate from mandatory law in a settlement agreement, unless this is contrary to public order or morality. So I cannot close a settlement agreement with Marcel about smuggling drugs into this building, for example, or into the Netherlands, because that's against a public order. But still, it's useful. But if we talk about a settlement agreement in Dutch employment law, we use it as a manner in which the employment contract can be terminated. So people say, we are making arrangements with respect to the termination of the employment contract, and we do that in the form of a settlement agreement. Rules provided in the Dutch Civil Code are also applicable to the formation and interpretation of settlement agreements. That's an important one to take note of. And finally, we also have a couple of rules in the Dutch Civil Code about, and then I call it the termination agreement. The termination agreement doesn't exist in Dutch law. We have some rules about when people make an agreement about termination of the employment contract, which are included in Article 670b of the Dutch Civil Code. And those rules are more or less, that agreement should be in writing. So the settlement agreement in which you terminate the employment contract should be in writing. And also the employee has a so-called reflection period of 14 days in order to dissolve the settlement agreement, or at least the termination of the employment relation. And I will come to that. But those are the two additional conditions with respect to terminating the employment contract through a settlement agreement. So you have to say the settlement agreement is the umbrella agreement, and termination of the employment contract is one of the forms in which it comes. So that with respect to the legal regime of the settlement agreement. Now let's get into what is a settlement agreement, what do we agree upon it. And how I would like to do this is that I will run through the most important aspects of that are included in a settlement agreement, and I've just taken as an example some of the considerations and articles that we include in our template in order to explain why is it in there, why do we include that, what's best practices in that regard. So yeah, usually a settlement agreement starts off, of course, with parties, and usually those are the employer, the employee, and those are the parties that sign the settlement agreement. I'm not going to go into much detail about that, but I do go in detail about the considerations of the settlement agreement. And the considerations are not what parties agree upon, but I usually say the consideration tells the story about your agreement. Why do we come to a termination of the employment contract? Why are we agreeing to this agreement? And another important aspect of those considerations are for the employee. Because the employee will likely, because you're terminating the employment agreement with the settlement agreement, the employee will likely have to go to UWV, the Dutch Social Insurance Agency, in order to apply for perhaps an unemployment benefit. And the UWV will look and will have to make sure that the employee is not culpable for his unemployment. And therefore the UWV will scan the settlement agreement, and they will have to see, okay, who is taking the initiative to terminate the employment contract, and is there an urgent reason, for instance dismissal, for example, underlying that initiative. And therefore it's important, for at least for the employee, to include in the consideration to make clear, okay, the employer is taking the initiative, there's no urgent reason for termination. So those are things important to the employee in order to be eligible to an unemployment benefit. So in this example, I've taken a more general consideration about why parties are coming to termination, because in practice it's quite difficult to come to an agreement. Why are we coming to termination? For example, in this case, I think this is connecting to perhaps a situation in which the employer thinks that someone is underperforming and the employee, for example, does not agree with that. But in the end, parties say, okay, we're going to come to a settlement agreement, and then you can include in the consideration that the employer is taking the initiative to terminate the employee's employment due to a difference of opinion regarding the manner in which the employee should perform its work. I want to make one important comment on this, is that what we see in practice is that employers come to us and say, Peter, Marcel, I have an employee who wants to leave, and he says, give me a settlement agreement, and then I'm gone. And then what that employee means with giving me a settlement agreement is saying, okay, write down that the employer is taking the initiative to terminate because I want to be eligible for an unemployment benefit, and then I would leave the company. And effectively, that's of course contrary to the truth, because the employee is coming to you saying, I want to leave. And we already have a manner in which you can terminate the employment agreement in that case, because that's resignation. So before you write this down and say, okay, it's okay, you're in the settlement agreement, I want to deal with this, want to be pragmatic, please be careful, because if you write something down that's contrary to the truth, for example, taking the initiative while you're not doing that, effectively is forgery, which is a criminal offense. So we want you to be very careful with that, please take that into account when writing something down that's perhaps not fully correct, or at least take advice on that. So that's with respect to considerations, or at least more or less the reason for termination, because you usually also include when did someone enter into employment, on basis on what kind of employment contract, things like that. But I think the reason for termination is an important one, or one of the most important considerations to include in the settlement agreement. Then I'm going to continue with my poll question, and this is more a quiz question for you guys, so don't be intimidated by it. But the question is, when determining the amount of severance pay in relation to a settlement agreement, so when you're drafting a settlement agreement and want to provide a settlement agreement to an employee, do you need to include the amount equal to the statutory transition allowance when determining the severance pay? Yes or no? And while you are giving your answers, I'm going through with one other aspect of the settlement agreement, which is, of course, the end date. Arguably the most important article in a settlement agreement. When does the employment contract between parties end with mutual consent? And yeah, in most cases you see that an employer takes into account the statutory or contractual notice period. So if, for example, an employee has a notice period of 1 month, and we're saying, oh, we're agreeing to a settlement agreement in September, the end date will be the 1st of November. That you don't have to necessarily do that, right? So you're not obligated to take account of the notice period when determining the end date in a settlement agreement. And you can say, yeah, we're going to agree upon an end date that lies on the 1st of October, for example, without taking into account the notice period. That is possible. And the reason for that is that Dutch law states, yeah, you can give notice as employer, and therefore you have to take into account the notice period. But with a settlement agreement, the form of termination is with mutual consent rather than giving notice. Giving notice is something unilateral, so you do that as an employer of an employee. I'm resigning, taking into account my notice period. We're giving you notice because of, for example, we followed the UWV procedure. But with a settlement agreement, you're saying, yeah, we're gonna agree to end the employment contract with mutual consent. So you don't have to necessarily need to take into account the notice period. However, what happens in practice is that an employee or his advisor will say, yeah, if you don't take, if we would not come to a settlement agreement, in other words, if the employee would not agree to a settlement agreement, you as employer, again, for example, would have to go to the UWV to obtain a dismissal permit. And in that case, you should take into account the notice period. So why should I agree to a settlement agreement that's less beneficial for me rather than following, for example, the UWV procedure? And it can be done because you can say, yeah, we're going to pay out or compensate you for the notice period in lieu. So we're going to pay you for that. That's of course possible. And another argument for taking into account the notice period for at least the employee is saying that, yeah, if you agree to an earlier termination date, then you're taking into account your notice period. The UWV will likely also not provide you with an unemployment benefit before the notice period lapsed. So again, for example, if we would have a notice period of 1 month and we would agree upon a termination date of the 1st of October, you will not get an unemployment benefit as from the 1st of October because you did not take it into account, and we call it then the fictitious notice period. So those, usually in most cases, the notice period is observed, and there could even be agreed upon a longer termination date. What if the employee finds other employment before the termination date? So in practice, we see also settlement agreements in which a longer termination date is agreed. So that could be March next year or April or May or whatever. And during that time, the employee will remain employed, will remain entitled to his salary. And it could be that, of course, the employee during that time finds other employment. What happens then? If you don't agree upon anything, that means that someone has 2 employments and gets his salary from the current employer with whom he concluded a settlement agreement, and has a new job and also receives his salary there. And it could be possible, especially if the employee is exempted from work, for example, by means of the settlement agreement. So he has the time also to work for his new employer. But what we usually include in settlement agreements is to say, if you find new employment before the termination date, then our employment agreement ends before that termination date, on that earlier date. So as from the date you starting with your new employer, and you, employee, are obligated to inform me when you find new employment. And in that scenario, you still remain entitled to your severance pay, for example, and you will still get a final settlement of accounts, but then you're no longer employed with us. Then I'm coming to also another important element of a settlement agreement, of course, severance payment. And before I'm gonna discuss that, I'm gonna look at the results of our poll. And let's see, what I said, when determining the amount of severance pay in relation to the settlement agreement, do I at least need to include the amount equal to the statutory transition allowance? And 31% said yes, and 69% said no. And the correct answer is no, indeed. Most of you have it right, because you don't indeed need to include the statutory transition allowance when determining the gross severance payment. You can also say, we're not going to pay you anything as an employee. That is possible. Of course, again, if you would have to pay the statutory transition allowance, if you would follow, again, for example, the UWV procedure, why would you agree upon any lower severance in a settlement agreement? It can be done because, of course, I think a settlement agreement, you have to look at it as a whole. So all the arrangements that we make. So you could say, I want to use I do not want the transition allowance as an employee, but I want a longer termination date, and therefore I want less severance payment or non-severance payment. So you can play with that. Let's put it like that in a possible negotiation with an employee. It's of course important, and that's also included in this arrangement, that you make sure that, if we are paying a severance amount, that we deem included in that amount a possible transition payment. So you want to avoid the situation in which you close the settlement agreement and an employee afterwards says, you still have to pay me a transition payment. So I think those are the most important remarks with respect to a severance payment. Then moving on with also an important, at least financial element of the settlement agreement, which is the final settlement. And this is quite a simple article to include, in which you say, okay, we're going to make a settlement of your employment. And in that settlement, which is usually paid out within 1 month after the termination date, we're going to pay you out any prorated holiday allowance, if applicable. And also usually included in the final settlement are the payment of holidays, accrued and non-taken holidays. And you can more or less do whatever you want with that. Of course, you have to agree upon it with the employee. But the starting point is that Dutch law states that if you, for example, give notice, so again, you come to termination through a UWV procedure, as an employer, you are obligated to pay out any accrued and outstanding holidays to the employee. However, for example, in settlement cases, employees tend to exempt someone from work. And so you're saying, okay, you're going to sign a settlement agreement. We're going to exempt you from work in order to give you some time to find new employment elsewhere. But in return, for that exemption, because that's something you give away, so to say, we want you to give up your entitlement to holidays. So we're going to your accrued and non-taken holidays are deemed to have been taken up before the termination date, because we think we're already exempting you from work, so we think we don't want to pay out any remaining holidays. But that's also part of the negotiation, could be part of the negotiation. It's also possible, for example, to say, we're just going to pay out your holidays and you have an exemption of work. You could also say, that's what I think is always a reasonable solution or compromise is to say, your accrued holidays until the date of signing the settlement agreement will be paid out, but any holidays that you accrue during an exemption of work are deemed to have been taken up before the termination date. In that way, you're not accruing holidays over a period in which you're already exempted from work, for example. But you have quite a lot of possibilities there. Of course, final settlement can not only consist of holiday allowance and holidays. I think those are the most common ones, but also you have employees who are entitled to an end of year bonus, other form of bonuses. So those are things to check at least when drafting a settlement agreement. Please make sure to look at, okay, what does the compensation of the employee consist of? Which elements are all those elements named in the settlement agreement? How are we going to treat those? Are we going to pay things out, or are we not going to pay things out? Things like that. I'm also looking at the time. I have to be a little bit speed up, but I'm almost at the end, so that's good. Then the final discharge, which is also an important one, and didn't include the whole final discharge clause that we normally use because it's quite extensive. But I think this is the important, the essence of a final discharge clause is that you say, yeah, we are gonna commit ourselves to the execution of the obligations from this termination agreement, so severance payment, final settlement, etc. And then we say, yeah, we don't have any further things to claim from one another. So not the employee from the employer, and the employer not from the employee. So for example, if you are an employer who provided the employee with a loan in relation to his employment agreement, please make sure to address that in the settlement agreement. You don't want to end up in a situation in which you have a loan which is not addressed in the settlement agreement, and the employee says, yeah, I've signed this, there's a final discharge, so we don't have anything to claim from one another. Yeah, that will be a difficult discussion, at least, to get back that loan, for example. Yeah, those are of course not all the important elements with respect to a settlement agreement. I just made a quick list of other things that I deem important in that respect. You have equity, so your restricted stock units, stock options, how do you handle those? In most cases, there's an underlying stock option scheme, for example, that also addresses the situation in which the employment agreement comes to an end, and how do we deal then with for example, the stock options or the restricted stock units. The exemption from work, I already addressed that. And then we also, of course, have the 30% tax ruling, which is for international employees, for internationals. It's important to take into account in that respect that a severance payment, the 30% tax ruling cannot be applied to a severance payment. There are a lot of other details regarding the 30% tax ruling that I'm not going to discuss right now, but it's good to keep that in mind. Of course, post-contractual obligations, how we're going to deal with confidentiality, non-compete, relationship clauses, and normally they would remain in full force and effect if, for example, someone would resign. Yeah, they're also in most cases part of negotiation, and of course an employee would like to make sure that the employer waives those post-contractual obligations, especially the non-compete and the relationship clauses, because that can stand in their way in their ability to find new work. Communication could also be a thing, and normally you would say, yeah, parties don't make any negative comments about one another. You could also make that more extensive and say, okay, we're gonna agree later on about the way we're gonna communicate to your organization, but perhaps also to third parties about the exit of the employee. The return of company property, a laptop, phone, company cars, things like that, also important to discuss or to at least address in the settlement agreement. Yeah, the statutory reflection period for the employee and for the employee only. So when you finally have your agreement with the employee, you have a settlement agreement, you think, oh, thank God, all is over. We had a tough negotiation, but we managed to get a settlement agreement with the employee. Please note that the employee, and only the employee, not the employer, still has 14 days to dissolve the settlement agreement without stating any reasons. And that would mean that settlement agreement is off the table, employee is still remains employed. There's still no termination of the employment agreement. So that's good to take into account. Then also penalty clauses that are mostly connected to, could be confidentiality clauses for the settlement agreement or post-reintegration clauses, also an important one. And then finally, a testimony. Most employees would like to have a positive testimony from their employer in order to find new work and positive references. So that's also an important aspect to take into account with respect to a settlement agreement. I see that we're almost out of time, so I had one slide. I'm going to skip this one. I'm going to look if we have any questions. I think I have a question for you, Marcel. Do you see in practice that companies introduce a voluntary leaving scheme? And I think that's in relation to indeed a reorganization.
Yeah, we do see that. Some companies do introduce that, or sometimes also it's part of discussions with unions, for instance, or with the Works Council. And the key reason for doing that is to at least see whether some people already are willing to leave the organization on a voluntary basis, and so that you don't need to make other people redundant who maybe would like to stay with the company. So it is something we do see. Be careful because there are also some elements that you do need to take into account, especially with drafting the correct wording for the voluntary leave scheme. So that's something to take into account.
Yeah, I can remember a situation with the Dutch tax authorities
Indeed.
in which a lot of people left and it was not the intention.
Yeah, many people raised their hands, and that's created quite some chaos.
Yeah.
Indeed.
Yeah. Right, thanks. We would like you to also fill in our evaluation for our webinar. That would be highly appreciated if you would take just, I think, 1 minute to answer those questions. I think they will pop up in your screen. And then, we're already at the end. So I would like to thank you, Marcel. I would like to thank all the viewers for listening to us. And like I said, if you have any additional questions that pop up after the webinar, feel free to reach out. I think these next slide are indeed our contact details. Again, slides will be provided afterwards. And then I want to thank you all for listening and viewing to our webinar. And hopefully we see you next time. Thank you.